Thank you so much, Kitu, for joining us. To begin, for someone hearing about the Deposit Protection Corporation for the first time, what is the DPC? What is its mandate, and why is it an important institution in the Zimbabwe's financial sector?
Thank you for the opportunity. Well, DPC is an important cog in the financial services sector because it's a crucial statute. It is the deposit insurance arm of government. It is a state entity that is run under the Minister of Finance. Our key mandate is to protect depositors. And by protecting depositors, we're talking about the growing of a fund. We collect premiums pegged at 0.3% per annum, which are collected from contributory banking institutions and microfinance institutions. And those funds are invested in the money markets and other asset classes, to grow the fund and to sweat that fund so that we can grow the numbers. DPC's mandate also extends to the liquidation of failed banking institutions. So once a bank is declared failed, the Reserve Bank hands it over to DPC for the liquidation processes to commence. So in a nutshell, I think that is what we do from an operational perspective.
You talked about collecting funds, you talked of funds. How big is the current fund size of this institution called DPC?
Okay, so DPC is not unique in the sense that whatever economic pressures are obtaining, it also succumbed to them in the past. DPC fund grew from $15.2 million at the end of 2024 to $29 million at the end of 2025. And currently, between December and now, it's sitting at 42 million, and we project that it will grow to 48 million by the end of the year. Relatively modest size in terms of size, but it's adequate in the sense that if any institution were to fail at this current juncture, our permutations are that we'll be able to liquidate that institution and to pay out based on the size of our fund.
Thank you so much about that. And still on that funds issue, could you update us? I understand the DPC was talking of reviewing its deposit insurance coverage. What's the current update? Did you manage to increase the levels of the insurance coverage?
Yes, I'm happy to report that as of the 1st of July 2026, we increased our coverage level from to $3,000 for contributory banking institutions and $2,000 for deposit-taking microfinance institutions, that's in US dollars, and in the Zimbabwe gold currency, that is the equivalent. So if your bank deposit is with a TMFI, which is a deposit-taking microfinance institution, that figure will be converted from US dollars to ZiG currency, and the same applies to contributory banking institutions. If it's in the ZiG currency, there's a conversion from the US dollars to ZiG.
Thank you so much about that. Now that we've gotten out of the way, we have told the viewers what DPC is, its current fund size, its the improvements that you have made to the DPC fund compensation fees. Now we are at a time where the DPC, I understand there is an ongoing bill. Against that backdrop, Parliament is currently considering the Deposit Protection Amendment Bill of 2026. What are the shortcomings in the current framework that has made this amendment necessary, and what does this bill seek to achieve?
That's a very loaded question, and the simple answer is we currently do not have a bank insolvency regime. What transpired is that in 2018, the Insolvency Act was amended from Insolvency Act Chapter 604 to Insolvency Act Chapter 607. And Section 4 of that Act indicate that that Act does not apply to banking institutions and microfinance institutions as well. So which means that we're relegated or we're disqualified from using the Insolvency Act to liquidate or resolve banks. And then in the same year, the Companies and Other Business Entities Act was also amended, and its Section 13 also indicates that that act does not apply to banking institutions. This was done deliberately by the lawmakers to make provisions or make way for the establishment of a dedicated special bank resolution framework for banking institutions, and that is taking heed of how unique and special banking institutions are which have a dual registration protocol, whereby they are first registered as companies under the Companies Act, and then they are then registered by the Reserve Bank under the Banking Act. So that also just shows you how special and unique banking institutions are. There's no way they should be resolved like any other institution, be it a hotel, be it a school, or any other institution. So this is what we're trying to achieve, to close that legal gap. So right now, because of the 2018 changes, we are sitting on a situation whereby we have no bank resolution regime, which is a legal lacuna we're trying to fill. Secondly, we realized that as we have been liquidating 9 institutions since 2003, there's been a lot of learnings and takeaways from those processes, and we are trying to arrest some of the mischief that we realized causes the demise of banks, in terms of the collusion and asset stripping that had been taking place within the institutions. So we've put in place provisions to ensure that depositors are their properties protected from collusion and other asset stripping behaviors, poor governance practices within the banking institutions. We are making directors and shareholders much more liable for the demise of banks than they have been in the past, and that is all going to be the key highlights of the DPC Amendment Act currently. We also took the opportunity to incorporate international best practice. You'll find that some key tenets of the IADI core principles, which is the International Association of Deposit Insurers, core principles have been codified and domesticated into our law, which is also best practice. So it's quite a loaded act, and it serves to arrest a lot of problems that we've been encountering. Another key development is that the Act also tries to ensure that in future depositors do not lose out from currency denomination or inflation. So we have written into the new law provisions that ensure that as long as there is residual assets for that bank, those residual assets shall not return to the shareholders. Otherwise, they are then supposed to continue to be liquidated until the creditors, who are our depositors, are paid in full and made whole.
You've talked about this new bill, part of its importance, to say you want to make sure that the directors of banks and institutions, they are made to be the responsibilities of bank failures. Is it the international best practice? That's one. Then was it the right judgment to arrive at, to say this would solve the current gaps that are there?
Yes, certainly, it certainly is. The last time the DPC Act was amended was in 2016, right? And that was a long time ago, that was 10 years ago. And with the changes that have taken place within our economy alone, and other risks that have come up, emerging risks that have come up in financial services sector, it would not be proper for us to continue using archaic laws like that. So what we've done is, obviously we've taken into account fintech and AI and what the rest of the world is doing on those fronts as well. So you see the changes to do with some definitions that we've realigned with international best practice, some record-keeping protocols that we've realigned with best practice. So I think it was the right call, bearing in mind the type of changes that have been happening in the past 10 years, as dynamic as the financial services sector, geopolitics, and so forth, and as they affect our own economy as a nation.
Part of the bill sections, it designates the DPC as the sole liquidator of failed contributory institutions.
Yes.
How would this improve the speed, efficiency of resolving failed banks vis-a-vis the previous framework that was being used?
It puts in place clarity. It makes it very clear what needs to happen. It just clarifies that and simplifies it to begin with. In the past, you'll find that there's a liquidation of an institution called Capital Bank. I don't know if you remember it.
Yes.
But DPC did not end up liquidating that one because the court appointed another institution, another private institution, to do it. So I think it makes sense to just put everything together and assign one institution that is also the payout champion on that issue. So DPC then becomes the sole liquidator of banking institutions, solely for banking institutions, leaving everything else that is not banking related to other players in the market that provide liquidation services, and then also dwelling up also as the payout compensation payout desk as well. So I think it neatens the whole process. It fosters confidence, and it just simplifies a very complex a process that has ordinarily been complex in the past.
Still on that issue, the bill also expands the powers of the DPC, including stronger enforcement measures and civil penalties. How would these new powers improve compliance without placing unnecessary pressure on financial institutions?
It will increase discipline first and foremost. The current DPC Act as it is had no penalties really, meaning that it had a lot of it was very verbose on issues to do with what institutions shall do, thou shalt do this and thou shalt do that, but it did not then provide consequences for the failure to act in certain ways or omissions and commissions. So what we've done is to ensure that we instill discipline within the sector to ensure that there's compliance with DPC Act and protecting the depositor in the process. It will also boost confidence. We're hoping that if institutions are liable for penalties and fines, they will rethink the way they've been approaching risks on depositors' finances.
Then depositor taking microfinance institutions are now being brought under the Depositor Protection Fund. Why was it important and what does it mean for financial institutions and depositor confidence?
Well, maybe to clarify that they've always been part of the Deposit Protection Fund. However, that did not emanate out of the DPC Act. It was out of the Microfinance Act and the Banking Act. So what we've done is we've taken that and also codified it into our act as well to ensure that there is, for the avoidance of doubt. So it's very important because you find most of our SME deposit book, a lot of our SME deposit book, and the unsophisticated depositor with low deposits, low income earners, they bank with microfinance institutions, deposit-taking microfinance institutions. So DPC's ethos is to leave no one and no place behind, meaning that all the depositors, no matter how big and how small their deposits are, should be covered by deposit insurance. So by extending deposit insurance and making it clear that it's under the DPC Act, we are sort of embracing that role of making sure that every class of depositor is catered for and covered equally and fairly, equitably by deposit insurance. So it's a very good step, which is just an emphasis, not to say it's a new development. It's just an emphasis and a codification of what's already been there, but in another law, not in our own law.
Thank you for that clarity. It brings clarity to those who are watching and those who are following the on proceedings of the amendment bill of the deposit protection. And also another question, Kitu, is to say the bill allows the corporation to require supplementary contributions during periods of systematic risk. Under what circumstances would that happen, and how does this strengthen the Deposit Protection Fund?
Okay, I'll start by explaining systemic risk. Systemic risk is a situation whereby, or systemic bank failure is a system whereby more than one bank fails, for instance, or a big bank that is of systemic importance to our financial services sector, our economy, fails. That is an institution or two or three or all of them, when they fail and the payout is so big that the Deposit Protection Corporation might not be able to sustain from its own fund, that is where a supplementary payout might be required or a premium might be required. So it's not for currently where we are with our fund, we are able to pay out for any institution that would fail as a singular institution. But where systemic risk happen and more than one institution fails or a systemically important institution fails, it would be important for us to take out a supplementary premium. That is under the IRD core principles as well. It's international best practice that we should be able to levy supplementary premiums on the market. We should be able to approach the government for emergency funding measures as well in that event to ensure that there is no further demise of the banking sector as a whole.
Kitu, as we conclude this interview, my last question to you would say, what does this bill mean for an ordinary depositor like me? What does it entail?
I think it should foster peace of mind. It should foster peace of mind that we've looked back into our history and seen the cries of our people and seen the losses that they've incurred in the past. And we've done our level best to ensure that those losses never happen again. That is to say that shareholders will never be considered ahead of ordinary depositors. Statutory creditors will also not be considered ahead of the ordinary depositor. So the deposits are safe in that if their bank fails, they'll be first to be considered. We've also strengthened our own power as a deposit insurer and made sure that we have a better grip on the market and the deposit and the deposits on the market. And this bill is actually has the best interest of the depositor at heart, and to ensure that in future no losses happen because of circumstances beyond the depositor's control.
Okay, and for also, finally, what message would you give to Zimbabweans about the safety of their deposits?
Their deposits are safe and sound. The DPC fund is growing, as I indicated, from December 2024, from $15.2 million to $42 million today is a phenomenal feat, and it continues to grow. By the end of this year, we're looking at a fund size of 48 million, and we're very confident that we can scale it up again with the type of investment decisions that we're making to stretch those funds, to grow the fund. So their deposits are safe and sound. In the event of a bank failure, DPC is ready and is armed to pay out. DPC is ready with expertise to execute any liquidation. We are currently undergoing the DPC Act amendment process. We are traveling with the Parliamentary Portfolio Committee next week, and we'll be in an area near you. That will be in Kadoma, Gweru, Blawayo, Masvingo, Mutare, and back in Harare again. So I encourage people to come in their numbers, depositors to come in their numbers, to hear more about the DPC Act amendments and the benefits that they stand to benefit, to gain, and to understand more about how the DPC as a player in the financial services sector is contributing towards the safety of the sector itself and their deposits.
Thank you so much for taking time, and thank you so much for answering our questions of the viewers, of the people watching at home, that they heard about the Deposit Protection Corporation as well as the amendment bill that is being tabled in Parliament. Thank you so much, Kit.
Thank you for your time. Thank you for having me.